All right, good afternoon, everyone. We're going to go ahead and get started. I see ACDC, I see Perm 2. All right, this is the State Expedited Accusations calendar in the State Court of Fulton County, Georgia. I am Judge Melanie Williams, and at this calendar, we'll set. Are you all able to hear me?
Yes.
Did you hear any of that I said before?
Yes.
Okay, I got muted for a second. All right. At this calendar, we'll address bonds for those individuals who've been recently arrested, but the cases have already been formally accused and bound over to state court. All defendants, you have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have a right to an attorney at this proceeding today. As you can see, I am not there in person with you. I am conducting this hearing by video. That means any member of the public can watch this. This proceeding is also being recorded. When I ask if you understand your rights, that is what I'm referring to. Have all defense attorneys had the opportunity to interview their client? Okay, I'm gonna assume yes. All right, can we take a position at
Before we
ACD?
do that, Your Honor, can I give you your reset date for
Oh,
your?
yes, that would be great. Thank you, Ms. Bridgewater. What is my reset date?
It's going to be May the 13th.
Thank you. Those who receive surety or cash are going to the May 13th all-purpose calendar, whereby aspects of the case can be revisited. Those who receive a signature bond will be reset further notice. All right. Who do we have first?
Good afternoon, Your Honor. Position 11, Ms. Sherton.
Thank you. Ms. Shurton, good afternoon. Your case is 25 CR 002259C. In this case, you are charged with battery, family violence. You understand your rights? All right, Mr. Howard.
Fourth arrest. Last arrest was May 19th out of DeKalb for trespass. 2023 trespass no-load. 2021 criminal damage to property dismissed.
Okay, thank you. Mrs. Sirocco, please proceed.
Thank you, Judge. This incident took place on December 22nd, 2024 at 7245 Connell Road. That's Connell Road in Fairburn. Law enforcement responded to a domestic dispute call and upon arrival made contact with the victim in this case, Ms. Laquita Sherton. That's Laquitta, who initially stated that officers previously at the location in reference to herself and two other females being in a physical altercation in front of the house. She initially claimed that she and her sister had nothing to do with it, but when the officers came back to where they were, the victim then admitted that they were the ones involved in the previous altercation. She explained that she got into a physical altercation with her sister, the defendant, who struck her in the face with a stick, causing 2 lacerations. She ultimately had to be treated and transported to Grady. The defendant had left by the time officers arrived, and a warrant was issued at that time. So that's the reason for the delayed arrest here. We have not spoken with the victim in this case. We'll continue those efforts. We would ask that the court sound for Ms. Sherton when appropriate, given the what sounds like potentially very disastrous injuries here. She had to be treated, had to be transported to Grady. The state's recommendation is a $1,000 surety, no further contact with Laquita Sherton. Stay away from 7245 Connell Road in Fairburn, and no drugs, weapons, or alcohol while out on bond.
All right, is Miss Laquita Sherton on the line and wishes to make a brief statement? If so, please unmute and raise your right hand. All right, hearing none. Ms. Bader, this is your client.
Yes, Judge.
In light of the information before me, I'm inclined to give your client a signature bond through pretrial. I would like particularly to hear your position regarding the no contact and stay away.
Your Honor, we have no objection to that.
Okay. All right, defendant is going to receive a $3,000 signature bond at level 2 through pretrial services. She's to have no contact with the alleged victim in this case, stay away from this location. have no alcohol, no drugs, no weapons as a condition. She's also going to take the 1-day anger awareness course. Is there anything additional?
Nothing from the state, Judge.
All right, best of luck to you, Ms. Sheraton. That concludes your case. Who do we have next?
Little position one next, Judge, and South Annex, Boyd.
All right. Position 1 is Boyd.
Appreciate it.
All right, good afternoon. Your case is 25 CR. Is it, I have to ask, after this, can we do Ms. McLeod's case, please? 25 CR 002249A. In this case, Mr. Boyd, you're charged with battery. Did you hear your rights?
Yes, ma'am.
All right, and you understand them?
Yes, ma'am.
All right, thank you. This is first arrest, so we'll go straight to Ms. Allen.
Yeah, what is his address? I was wondering that.
Do we know?
7501 Red Oak Road.
Okay. Ms. Allen, please
Thank
proceed.
you, Your Honor. This is an incident that occurred at that location on the 24th of April. The victim is Victor de la Cruz Garcia. Police responded to a dispute call there, and they met with Mr. Garcia, who was described in the documents as being severely injured due to a physical dispute with this young man. He is 17. He reported that the victim, or the defendant reported that he responded with violence because the victim called him a racial slur, and that is what caused him to strike him. We're asking for a $3,000 SOB through pretrial, no contact with Victor de la Cruz Garcia, and no drugs, alcohol, or weapons, Your Honor. And we would ask for some information about a parental cosigner or how this young man spends his days, because maybe a curfew is appropriate. Thank you. If
All
you
right.
think for Mr. or sound for Mr. De La Cruz.
Is
Correct.
Mr. De La Cruz present, wishes to make a statement? Hearing none. Ms. Bader, I'm inclined to accept that state's recommendation. I do have a question. Is your client a high school student?
He is, Your Honor. He is a junior at Creekside High School, and he also works at McDonald's. He has a grandmother and cousins who are local, and the grandmother's online.
Okay, and that would be his cosigner?
If she's able, I haven't had the opportunity to speak with her personally. Looks like she's nodding her head yes.
Okay, we need the grandmother's name. Ma'am, can you just unmute and give us your name? You're still muted. You're still muted. We need to have your name if you're gonna co-sign for your grandson.
She's not in here.
That's your mom.
That's my mother. Is it?
Oh, that's your mother? Okay, well, we need your mother to unmute then.
I'm here. I'm here. I'm here.
And you're gonna co-sign for your son?
Yeah, my grandson. Yes, my name is Rebecca Pace.
I'm sorry, your name is what?
Rebecca Pace.
Can you spell your last name for us?
P as in Pam, A as in Apple, C as in cow, E as in elephant. Pace.
All right, thank you. Defendant is going to receive a $3,000 signature bond at level 1 through pretrial services. He's to have absolutely no contact with the alleged victim in this case, have no alcohol, no drugs, no weapons. He will be reset to the all-purpose calendar, and his mother, Rebecca Pace, will co-sign for him. Is there anything additional from state or defense or Mr. Howard?
I'm his grandmother, Your Honor. I'm sorry.
Oh, I'm sorry, his grandmother. All right.
Yes,
Anything
ma'am.
additional from
Okay.
state defense? All right. Best of luck to you, Mr. Boyd.
Excuse me, Your Honor. You say he's reset to the all-purpose calendar?
I'm sorry, he's reset for the notice.
Okay.
And he it's a 3,000 at level 1. All right, and he must also stay engaged in school. All right, best of luck to you, Mr. Boyd. That concludes your case.
Thank you.
Position seven next, Judge.
I'm sorry, what position?
Position 7. She has a private attorney in the office.
Okay. All right, counsel, please just note your appearance, your name, sir.
Sure. This is Samuel Round, and her attorney for this particular first occurrence.
Okay, thank you. Your name is Maya Kapchak, is that correct?
Yes, ma'am.
All right, your case is 25 CR 00228. I'm sorry, 2258C. You're charged with hit and run, failure to maintain a lane, driving with a suspended license, and a false report of a theft. Do you understand your rights today?
I think so.
Is that a yes? You understand your rights?
Yes, ma'am.
Okay. Mr. Howard?
Second, 2017 simple assault dismissed.
Okay, thank you. Mr. Sirocco?
Thank you, Judge. This incident took place, or it began at least on January 9th, 2025 at roughly 10:30 on Piedmont Road Northeast and the entrance ramp near the entrance ramp to I-85 southbound Atlanta. Law enforcement was dispatched to a hit and run involving two vehicles. Upon arrival, the officer spoke with the victim, Miss Mary Tabor Sirensen. That's TABOR-SIERESEN, who explained that she was proceeding north on Piedmont Road when a U-Haul box truck crossed into her lane and collided with her vehicle. The victim's vehicle sustained damage to the right front side and passenger side mirror. She was able to capture a short video of the suspect's vehicle, confirming the license plate number as it fled the scene. Obviously, did not stop to share information or anything of the like. She explained that the driver of that U-Haul was a white female who made no attempt to stop, and subsequently, on January 13th, 2025, the defendant actually contacted APD to report a U-Haul, the U-Haul truck that she was renting, stolen from in front of Pepper Boxing Gym at 3090 Early Street. Defendant claimed that she had moved the vehicle on January 8th from the Buckhead Theater to that parking lot due to parking tickets, and that she and her team had gotten sick from then until January 13th, 2025. Camera footage from January 9th, 2025, showed a white female with blonde hair matching the defendant's description, taking the U-Haul from in front of the Buckhead Theater. So after she claims it was stolen. Defendant stated the truck was large, would jump around when she drove it, and that if she hit another vehicle, she was unaware of it and would go to City Hall to take care of it. She was unable to explain the vehicle being in the vehicle, on January 9th. She claimed memory loss, and later admitted to driving the vehicle on January 9th and having issues parking it at Target after leaving it at the Buckhead Theater, apparently. Her license had been suspended since it would have been August 28th, 2024, and she had surrendered it on roughly a week before all of this on January 3rd, 2025. Warrants were taken out for her arrest. I do see there are several FTAs here. Those are actually the reasons for her license suspension. She FTA'd on April 23rd of 2024, and her license was suspended for that. And then she also FTA'd for what looks like a trial on November 26th, 2024. We would ask the court sound for Mary Tabor Searson when appropriate. And well, given the failures to appear and the risk to public safety that this sort of driving poses, the state's recommendation for each count of the 4 is $1,000 surety on each. No drugs, weapons, or alcohol while out on bond, and no driving without a valid driver's license.
All right, I'm gonna sound for Miss Mary Tabor. What was it? Searson, very
Searson.
quickly.
I believe that's how you say it.
All right, is that party present? I want you to make a very
Stevenson, John. Your Honor.
Stevenson. Okay, is that party present? All right, counsel, please proceed.
Well, two things. First, apparently on August 28th, 2024, her license, you say, was in suspension, yet on that same day, she was able to rent a U-Haul. I don't know how that happened, because I would assume that the U-Haul people would not rent to a person who has a license in some sort of suspension, but I don't know. All I do know is that we have a victim supposedly who's not here today to say exactly what happened, but apparently there was a report of some sort of a collision. And I don't know that she's being charged with any of that, but I thought that I heard that she was being charged with saying, returning the vehicle and saying it was stolen when it wasn't stolen. And somehow, as best as I'm understanding it, what happened was that there was a collision of some sort, and now that happened on January the 9th. Then several days later, on the 13th, she reported that as a stolen vehicle and not as a vehicle that had been in a collision. I don't know what happened in the interim between the 9th and the 13th, but I don't know, and I guess the court doesn't know. But it just seems to me that we're not going to argue about whether or not she's guilty. That will come later at another date. It seems also to me that we could ideally have a signature bond. If not, I looked very briefly at these charges. They're like a whole series of different charges. A lot of them are similar, although they have different case numbers or different warrant numbers.
If I could just very briefly.
No, no, Mr.
expand.
Rocco, I've got it.
Okay.
All right. I'm sure you all will continue to argue about this. Defendant is going to receive a $4,000 split bond. Let me break it down. First count will be 1,000 surety. The remainder will be each 1,000 through the jail. So she's only got to make bond on the $1,000 surety for count one, the hit and run. The remainder will be signature bonds through the jail. She's not to drive unless she has a valid license. She's have no alcohol, drugs, weapons. And because of the surety bond on the first count, she is going to be going to the all-purpose calendar on the 13th. Otherwise, the other charges will not have any hold on her. All right, and very briefly, is there anything additional from the state of defense? Very briefly.
Yes, Judge, and this is not argument. I just wanted to, for the I forgot your name, apologies, but for the defense attorney's edification, there were 4 charges and then an additional 4 charges. The subsequent 4 appear to be duplicates. As such, we've dismissed those.
Okay, thank you for that, Mrs. Rocco. I do appreciate that clarification. All right, is there anything additional from state of defense at this point?
No.
All right, best of luck to you, ma'am. That concludes your case. Thank you.
Thank you. And if I can get the documentation or a copy of that, I'll take it to deal with this $1,000 bond.
Okay, well, the orders will be sent to the jail when we finish court, okay?
Good. Thank you.
All right, best of luck to you both. Take care. All right, who do we have next? Oh, can we do Ms. McLeod's case?
Yes, we can do a position, Mr. Palmer.
And Ms. McLeod, you're here? Oh, I don't see a Palmer on the calendar. Is there an add-on calendar?
Your Honor, that was a dismissal.
Okay, so Mr. Palmer's case has been dismissed.
Okay, that's good.
All right, is there any other case that's Ms. McLeod's?
Yes, Your Honor.
Who's your other client, Ms. McLeod?
My other client is, let me pull up the information, I'm sorry. My other client is Mr. Brookings.
Mr. Brookings, B-R-O?
O-K-I-N-G-S.
Mr. Brookings doesn't appear on this calendar either.
Yes, Your Honor, that case was dismissed as well.
Okay,
All right.
nobody told me. Okay, thank you. I guess that concludes my business for the court today.
Take care, Ms. McLeod. I'm glad we checked. Have a good afternoon.
You too, Your Honor.
Okay. All right, who do we have next?
Position 14, Ms. Young.
Ms. Young, your case is 25 CR 002248Y. You're charged with simple battery and battery family violence. You understand your rights? All right, Mr. Howard.
6, on probation for ag assault. Got an open DUI, 2023 probation.
Okay, thank you. Ms. Allen?
Thank you, Your Honor. This is an incident from the 28th of April. It took place at 4950 Buckeye Place in Atlanta. This is a single count of civil battery family violence. Police were dispatched to the location about a physical dispute. They spoke with Sherry Walker, who said that she'd been in a dispute with a minor, initials JP. She said she heard the defendant, Brittany Young, screaming at a minor and went to see what was going on. She saw the defendant swinging on the minor with a closed fist and striking her in the face. She tried to intervene. And then the defendant pulled her hair, ripping hair out of her head. She said this is not the first time that there's been a physical altercation. The defendant was under the influence and allegedly, based on the statement of the witness, starts fights with this minor JP for no reason. It looks like there are prior arrests for violence as well as substance abuse. We'd ask for a signature bond through pretrial. Your Honor, stay away from JP, the minor. No drugs, alcohol, or weapons while on bond. And if you would sound for anyone, I guess there's some confusion about where this defendant lives. There should be a stay away from the minor JP in that location.
Okay. I'm guessing I'm not sounding for the minor, and I really don't need to hear from the witness at this point.
I believe the witness is the mother of the minor, Your Honor.
Do you know the mother of the minor's name?
Walker, I believe she's here on the Zoom.
Okay. Ms. Walker, if you want to make a very brief statement, please turn on your camera.
Just as it pertains to living situation and if there's a stay away that's needed, that would be the only reason.
What is the relationship between the minor and the defendant? Do we know?
If Mrs. Walker could assist with that.
Ms. Walker, are you present? Please unmute.
The information I have is that the defendant doesn't live there, but has been staying there for a week as she looks for a place to live.
But she's not like blood related to the minor child, supposedly.
That's the minor child is my granddaughter.
Wait, hold on, please raise your right hand. Do you swear or affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes.
All right, Ms. Walker. So the relationship between the defendant and the minor child is what?
So Brittany is my child, and the altercation was with my granddaughter, her child.
Oh, her own child. Okay.
Yes.
Okay. And the defendant does not currently live at that address?
The minor child does live with me.
But the defendant does not.
Well, she's been here for about a little over a week. But prior to that, no, she had not been living with me.
Okay. Is there anything else you'd like to tell me?
No.
Okay. Ms. Bader, I'm not inclined to give the signature bond, so why don't you tell me about your client?
Your Honor, Ms. Young is 38 years old. She's lived in Georgia her whole life. She has good ties to the community. She does have her GED. She does have a good stable job. She works with International Operations Agent, moving air and ocean freight. She's been in this line of business for 5 years, and she's been with this particular company since last summer. So she has been able to make good strides in her life, and she has this important job that she would like to get back to. She is in a relationship, and her partner lives in Union City, so she plans on living there. So we do not object to the stay away. Judge, at this time, as you heard, the child lives with her grandmother. So they would not be living under the same roof. And my client at this time does deny these allegations, but we don't object to the no contact and stay away.
Okay.
So we would ask for the signature bond. If not, we would ask for the bond to not exceed a $1,000 good bond.
All right. Defendant is going to receive $1,000 good bond, 500 on each count. She's to have no contact with the minor child at this time. That can be revisited at a later date, of course. She's to stay away from that location. She can return one time with a member of law enforcement to get any items she may need to get. She's to have no alcohol, no drugs, no weapons as a condition, and she is going to the all-purpose calendar on May the 13th. Is there anything additional from the state or the defense at this time?
No, I apologize. There are 2 counts on this case. I misspoke. Thank you.
All right. All right. I'm sorry. Anything additional for Ms. Bader?
Nothing additional, Judge. Thank you.
Go to position 4, Judge. Ms. Brown?
All right. Good afternoon, Ms. Brown. Your case is 25 CR 0022528. You're charged with 2 counts of battery. Do you understand, right?
Yes.
All right, Mr. Howard.
9th arrest. Open trespass out of Clayton County. On probation in Clayton County for ag assault. 2024 probation. 2021 trespass conviction. 2017 probation and fade to appear.
Okay. Ms. Melgizo, please proceed.
Good afternoon, Your Honor.
Good afternoon.
This incident is from September 7, 2024. The location is Soltis Apartment Complex at 1111 Oakley Industrial Boulevard, Fairburn, Georgia. Officers spoke with the first victim, the Tyla Brewer, who stated that the defendant is a friend. On the day of the incident, they were celebrating the defendant's birthday at the incident location, which is where both victims live. The defendant consumed several alcoholic beverages and became aggressive. Because of the defendant's behavior, the victim Brewer asked the defendant to leave. But the defendant attacked her and punched her in the face with a closed fist. The officer also spoke with victim number 2, Ms. Deborah Gore, who stated that the defendant was angry and struck her in the face. Ms. Gore stated that she attempted to prevent the altercation from escalating by holding back the defendant, and that is when the defendant struck her in the eye, and then the defendant left the location. Several other people that were in the apartment told officers that they observed the defendant strike both Ms. Brewer and Ms. Gore. Officer observed that both victims had swelling. Ms. Brewer sustained swelling to her right eye, and Ms. Gore had swelling to her left eye. Your Honor, based on the history and the nature of the incident, the state's recommendation is a $1,000 surety, stay away from Soltis Apartment Complex, no further contact with Ms. Brewer and Ms. Gore, no alcohol, drugs, or weapons while on bond. If we can please sound for the victims in case they are present and wish to be heard.
All right. Are either Ms. Brewer or Ms. Gore present today? All right. Hearing none. Ms. Bader?
Yes, Judge. Ms. Brown is 25 years old. She lives with her 2 children, ages 4 and 1, in McDonough, Georgia. She does have ties to the community. Her mom, sister, brother, grandmother, she's all close with, all live in Georgia. She's been here her whole life. She does have, she is gainfully employed working at a temp service. Judge, in terms of the alleged facts of the case, Ms. Brown does contend that she was not the primary aggressor in this situation. We wouldn't object to no further contact with the complaining witness in this case, Ms. Gore. And if the court is willing to consider, we would ask for a signature bond.
Okay. All right, defendant is going to receive that $1,000 surety bond, 500 on each count. She's to have no contact with either of the alleged victims in this case. Stay away from that location. Have no alcohol, no drugs, no weapons.
That's a surety bond, Judge?
Yes, surety. And she's going to all purpose on the 13th.
We can go to position 9.
Okay. This is Ms. Range. All right, your case is 25 CR 002254H. You're charged with simple battery family violence and simple assault family violence. Do you understand your rights? Is that a yes?
Yes.
All right, Mr. Howard.
Second, 04 simple battery DV first offender.
All right, Mr. Sirocco.
Thank you, Judge. This incident took place yesterday, April 29th at 520 West Campbellton Street in Fairburn. Law enforcement responded to a physical domestic violence call there. Upon arrival, made contact with the victim, Mr. Emmanuel Streeter, who explained that the defendant, who is his mother, had pushed him out of the front door of the residence and then attempted to throw a chair at him. He explained further this occurred after he came back from the house, after going to the store, some argument over money. And they got into an argument. He began to pack his belongings and leave. While he was doing that, she pushed him out of the door and then attempted to throw a chair at him. The defendant, when the officer spoke with her, actually admitted that the victim was being disrespectful with her, that she was tired of him. And she told him to leave and never come back. She admitted that she did push him out the door and throw a chair at him. With respect to victim contact here, we have not been able to reach Mr. Streeter. We would ask the court sound for him when appropriate. On account of the previous battery family violence, while it is older, it is a battery family violence nonetheless. State's recommendation for this is a $500 surety bond for each count. No further violent contact with Emmanuel Streeter. With respect to a stay away, it sounds like this would be her home and not his, but we would ask for clarification on that and defer to the court, as well as no drugs, weapons, or alcohol while out on bond.
All right, is Mr. Streeter present, wishes to make a statement? All right, Ms. Bader, I'm inclined to give your client a signature bond through pretrial, but I do need to clarify, is that your client's home?
It is my client's home, and she does have 4 children even younger than this particular son. So she is eager to get back to this particular home. His father, he picked him up and he is living with his father now. So Mr. Streeter, as far as I'm concerned, is now with his father and not in this home.
All right, and there was no further violent anyway requested by the state, which I'll agree with. Defendant is going to receive a $2,000 signature bond at level 1 through pretrial services, which is going to be $1,000 on each count. Defendant is going to take the 1-day anger awareness course, have no further violent contact with the alleged victim. I'm not going to include a stay away. Have no alcohol, drugs, weapons, and will be reset further notice. Is there anything additional from state or defense?
Nothing from state.
All right, best of luck to you. Who do we have next?
We can go to position 2, Mr. Briscoe.
Okay, Mr. Briscoe, good afternoon. Your case is 20. Oh, shoot. All right, there we are. 25 CR 002246E. You're charged with battery family violence. You understand your rights? All right. That's first arrest. We'll go to Ms. Melgizo.
Well, yes, Your Honor. This incident is from April 28th, 2025. The location is 2958 Webb Bridge Road, Alpharetta, Georgia. Officers responded to a domestic disturbance and made contact with the victim, Frances Irwin. Ms. Irwin stated that she and the defendant, with whom she has cohabitated for approximately 4 years at the incident location, were involved in a verbal argument. During the argument, the defendant began throwing Ms. Irwin's personal belongings throughout the home and into the backyard. In response, Ms. Irwin picked up the defendant's laptop. The defendant then attempted to retrieve the laptop by forcefully grabbing Ms. Irwin's upper arm. The officer observed visible red marks on Ms. Irwin's upper right bicep, consistent with her account of being grabbed. Ms. Irwin also had multiple bruises, but she clarified that the bruises were related to medical treatment and not caused by the defendant during the incident. Your Honor, we did speak with the victim today. She confirmed the events in the warrant. She stated that they're in a relationship. They live together at the incident location and they share one child. She said that this is not the first time the defendant has been violent with her and not the first time police has been called, but this is the first time he has been arrested for violence against her. She wants no contact with the defendant and she wants him to stay away from the residence. Your Honor, the state's recommendation is a signature bond through pretrial, stay away from the location 2958 Webb Bridge Road, Alpharetta. No further contact with Frances Irwin. Third-party transfer if the defendant wants to see the child. No alcohol, drugs, or weapons while on bond. If we can please sound for Ms. Irwin in case she wishes to be heard.
All right, Ms. Irwin, I see you on the screen. I'm sorry, Ms. Melgizo, I didn't mean to cut you off. Ms. Irwin, I see you on the screen. If you wish to make a statement, please turn your camera on, raise your right hand. You're not required to make a statement, however, but if you do, this is your opportunity. Okay. Mr. McLean, do you have any objection to the state's recommendation, which I'm inclined to accept at this time?
No objection to the signature bond. We just need to clarify for sure about the living arrangements if the court is inclined to separate. Thank you.
I'm inclined to accept and say no contact because I have not heard from Ms. Irwin. Would you like to speak to that, Mr. McLean?
Your Honor, I have, I'm not sure who pays for it, who's going to stay. Mr. Briscoe?
Yes, sir.
You can directly answer this. Who's going to stay at the apartment?
Your Honor, the no stay.
Don't say too much. You might say something by mistake. Be
No,
careful. You have a right to remain silent.
Ma'am, I have my son, and we do not share a child. It's my son through a marriage with my ex-wife. My question is my son will be with me this weekend, and I would like to have him at my residence. Miss Irwin does have family members in the Norcross area that she can take residency. And in fact, she was moving some items leading up to our disagreement on Monday.
All right.
I realize that in absence of her presence, we have to rely upon the deferring to the court.
Exactly. All right. So I have considered all the information before me. Defendant is going to receive a $3,500 signature bond at level 1 through pretrial services. He's to have no contact with the alleged victim at this time. I am going to exclude him from this residence as we're not going to exclude the alleged victim, and I did not hear any information about where she intends to reside from her or the state. He can return one time with a member of law enforcement to ascertain whether she's there. If she has moved out, he can return to that location. If she's still residing there, he can collect his things on a one-time basis and go to a different location. Additionally, he's to have no drugs, no alcohol, no weapons, and will be reset further notice as this is a signature bond. Is there anything additional, Mr. McLean or Ms. Malgisa?
No, Your
No,
Honor,
let me just,
Your Honor, this is Francis Irwin. May I say anything?
I sounded for you twice.
Yes,
Please
ma'am, I
turn on your,
apologize. I couldn't
turn
figure,
your camera on, raise your right hand.
I'm trying to figure out how to do that, ma'am. I'm so sorry. Start, okay. There we go.
Do you swear or affirm testimony you give today be true to the best of your knowledge?
Yes, ma'am.
All right. Do you wish to have contact with the defendant, and do you have any concerns for your safety?
I do have concerns for my safety and I do not need to have any contact with him.
All right. Do you intend to reside at that residence?
Yes, ma'am.
Okay. Well, if the ruling still stands, apparently that'll be the same. If please come, it will be the same situation. So there's no adjustments needed. All right. Is there anything additional from state or defense? All right. Best
no,
of
Your
luck
Honor.
to you, Mr. Briscoe, and all parties concerned. All right. Who do we have next?
Position 3, Mr. Brown.
All right. Are you James Brown?
Yes, ma'am.
All right, Mr. Brown, your case is 25 CR 002253B. In this case, you are charged with hit and run and in driving in an improper lane. You understand your rights?
Yes, ma'am.
All right, Mr. Howard.
17. I didn't see any driving related arrests.
Okay, thank you. Ms. Malgisa?
Yes, Your Honor. This incident is from September 12th, 2024. Officers responded to a two-vehicle collision. One vehicle was a Honda Accord driven by the victim, Mr. Derek Wyche. The other vehicle was a 2007 Ford driven by the defendant. The incident was recorded on FUSUS camera system. In the video, officers observed that the Honda was legally stopped at the light facing southbound on Fairburn Road. The Ford was traveling on Martin Luther King Jr. and was traveling faster than was safely feasible under the weather conditions. It had been raining that day. As the Ford entered the intersection, the defendant lost control of the vehicle and spun out of control through the intersection while spinning. The Ford crossed over the center lane on Martin Luther King Jr. Drive and then continued sliding out of control over the center lane on Fairburn. While sliding, the Ford collided with the Honda. Both vehicles slid backwards after the impact before coming to a rest, with the Ford alongside the Honda completely spun around and facing southbound. After the collision, the defendant attempted to back the vehicle up and dislodge it from the Honda in an attempt to drive away, but he was not able to. The defendant then walked away from the scene without exchanging information or otherwise attempting to render aid. He abandoned the vehicle and did not return. During the course of the investigation, the officer was able to get a hold of the defendant by phone since he is the registered owner of the Ford. During the conversation, the defendant told the officer that he was the driver on the night of this collision and agreed to come to the Atlanta Police SOS precinct and sign citations in connection with this collision. The defendant did not show up on the scheduled day and has since stopped answering the phone. Your Honor, this defendant has a 2020 FTA, 2020 probation violation, and 17 other cycles. Based on the nature of the incident and the criminal history and the FTA, the state's recommendation is a $3,000 surety bond, no alcohol, drugs, or weapons while out on bond. That is all for the state.
All right. I'm inclined to give this defendant a signature bond with a restriction on driving, unless he has a valid license. Mr. McLean, any objection?
No objection, Your Honor. Have a valid address and got plenty of family in town for community contacts. Thank you.
All right, defendant is gonna receive $3,000 signature bond through the jail, 2,000 count one, 1,000 count two. He's not a driver unless he has a valid license issued by the state of Georgia, have no alcohol, no drugs, no weapons. Sir, I'm giving you an opportunity here. Do not miss any additional court dates. All right? All right, best of luck to you, Mr. Brown. Who do we have next?
Got position 5, Mr. Costello.
Mr. Cosby, your case is 25 CR 002257J. You're charged with obstruction. Do you understand your right?
Yes, ma'am.
Mr. Howard?
45 on probation for burglary. 17 SC 154986. Got an open shoplifting felony. 25 PI 000688. 2025 failure to appear. Probations from 2023, 2014 robbery conviction, 2017 trespass conviction, 2019 FTA, and a 2022 battery conviction.
All right, thank you. Ms. Melchiso?
Yes, Your Honor. This incident is from April 28th, 2025. While en route to respond to an active incident, officers observed an individual standing at the corner of Sylvan Road and Cleveland Avenue, near 890 Cleveland Avenue in East Point, Georgia. The individual matched the description of the suspect involved in the incident to which the officers were responding. The location of the individual was in close proximity to the original call for service. An officer approached the defendant and asked for his name. In response, the defendant questioned the reason for the inquiry. The officer explained that he simply wanted to ask him a few questions and determine where the defendant was coming from. Without further provocation, the defendant abruptly fled on foot into the middle of Cleveland Avenue, placing himself in immediate danger and nearly being struck by oncoming traffic. This action created a hazardous situation not only for himself, but for motorists and the officers involved. The officer pursued the defendant on foot and was ultimately able to detain him at 2717 Sylvan Road in East Point, Georgia. Your Honor, when this incident took place, the defendant was out on a signature bond through the jail for PI case. He also has an open probation violation case. So the state's recommendation is a $500 surety bond, no alcohol, drugs, or weapons while out on bond. That is all for the state.
All right, Mr. McLean?
Your Honor, 49-year-old Mr. Cosby, who occasionally they misspell his name, does live on Avenue in a certain apartment. His address, he has stable phone numbers and contacts. He went through the 9th grade and has applied himself tremendously since then. He works maintenance with a local agency for over 10 years. He would ask the court to consider, and I would rely partly on the fact that it is a one-count obstruction case and nothing else. What happened to the suspect business, maybe that'll be in the future. But if not, he would serve a signature bond in our opinion. Thank you.
All right, the defendant is going to receive a $25 cash bond. He's to have no alcohol, drugs, weapons. Because it's the cash bond, he is going to all purpose. Is there any? Yes, that's correct. All right, is there anything additional from the state of the defense?
No,
All
Your
right.
Honor, nothing further for the state.
All right, hearing none, best of luck to you, sir. Who do we have next?
Position 6, Mr. Paul.
All right, Mr. Fall, good afternoon. Your case is 25 CR. Is Mr. Fall coming? 00227, I'm sorry, 2247D. Do you understand your rights today? You're charged with simple battery family violence in this case.
Yes, ma'am.
All right, Ms. Melgizo, I have that this is first arrest. Please proceed.
Yes, Your Honor. This is from yesterday, April 29th, 2025. The location is 7325 Wright Drive, Atlanta, Georgia. Officers spoke with the victim, Mr. Aliu Paul, the defendant's father, who stated that earlier in the day, he received a text message from his son that stated, "If my dad tries something, I'm going to beat his ass." Mr. Fall thinks that the defendant was unaware that he had sent the threatening messages directly to him and not to the intended party. Mr. Fall told officers that he took the defendant's phone when the defendant got home, and the defendant grabbed him, trying to get his phone back. The officers then spoke with the defendant, who admitted to grabbing his father and also stated that he held down his father on the ground in an attempt to retrieve his phone. The defendant also presented text messages with a friend in which he mentions that he will fight his father if provoked. Based on the information above, the officers determined that the defendant was a primary aggressor. We did speak with the victim today. He stated that him and his son, the defendant, lived together. He stated that nothing like this has ever happened before. He's not in fear of the defendant, and he wants him to return home. The state's recommendation is a signature bond through pretrial, 1 day anger awareness, no further violent contact with Mr. Aliu Fall. And I'm sorry if I'm mispronouncing that. That is Alione. No alcohol, drugs, or weapons while out on bond. If we can please sound for Mr. Fall in case he wishes to be heard.
All right, Mr. Fall, please raise your right hand and unmute very quickly. Unmute. Unmute, please. We need you to unmute very quickly. We can't wait on this much. You're still muted.
Unmute, right here.
All right, do you swear or affirm testimony you give today be true to the best of your knowledge?
Yes.
All right, very briefly, what would you like to tell me?
Okay, so basically what happened in the morning around 11 during the day.
No, okay. Let me give you some instruction. The
Okay.
state has presented the evidence to me about you. There's going to be other hearings about what happened, and if you disagree with what the facts that Ms. Melgiso set forward, that's not what I'm concerned with. Your son is accused of a misdemeanor offense, and he's entitled to a bond today. What I'm most concerned with are, concerns that you have for your safety and whether you wish to have desires for contact. There will be other opportunities for you to flesh out the facts about what happened. Okay? So what would you like to tell me with those instructions?
He can come home. There is nothing to worry about. He was just a miscommunication.
Okay. And you have no concerns for your safety at all?
No.
All right, understood. Thank you. I appreciate you coming to court and making that statement. I understand that it is brief, but this is a bond hearing and there'll be other opportunities, okay? And I'm sure some other parties will reach out to you about that case, Mr. Fall. All right,
All
Miss.
right, thank you.
Thank
Is he
you
gonna
so
get
much.
released today?
We're gonna see. We'll see what I decide to do. I haven't made a decision yet. Okay.
Okay.
Mr. McLean, I'm inclined to give your client a signature bond through pretrial services at level 1. Do you have any objection to that?
I do not. He's in high school and he works on top of that. He's college bound. He's in the 11th grade. Thank you.
Okay, so he needs to stay engaged in school. Mr. Fall, this is
Yes.
not you, I'm speaking to your son. Mr. Fall, this is a very serious thing you are charged with today. I'm giving you an opportunity today to have a second chance. You need to stay engaged in school as part of this signature bond that I am giving you. All right. Technically, his father should not be the co-signer because he is the alleged victim in this case. Mr. Fall, is there someone else who can sign your son's bond?
I don't have anybody. What I can find it. Well, he can sign it, right?
No, he's underage, so we need someone other than yourself who can sign that bond for your son. Do you know who that party would be?
I can bring a friend who can sign it. Yes.
We're gonna need that person's name now, though. Do you know that person's name?
Hold on. Let me think.
Why don't you put yourself on mute and come back to us in a moment, okay?
Okay, we'll do.
Defendant is going to receive a $3,500 signature bond at level 1 through pretrial services. He is going to take the 1-day anger awareness course. He's to have no further violent contact with the alleged victim, and as a condition of this bond, he must stay engaged in his high school education. Additionally, he's going to have a co-signer And that will soon be supplemented to us before we leave. Mr. Fall, please do that in the next 10 minutes, please. All right. Thank you. Best of luck to you, Mr. Fall. Who do we have next?
Position 8, Mr. Pitts.
All right, Mr. Pitts, your case is 25 CR 002255F. In this case, your charge is simple battery, family violence, hindering a person making an emergency call, and obstruction. Do you understand your right?
Yes, ma'am.
Thank you, Mr. Howard.
33. Got an open burglary in the first, theft by taking, trespass. 25 SC 001 Got an open false imprisonment, battery DV obstruction. 25 SC 001 360. Got an open drug case. 25 SC 000607. Open case from 2023 drugs. Open case out of DeKalb County, battery DV, violating a family violence order. 2025 FTA, 2017 simple assault conviction.
That's good. Thank you, Mr. Howard. Ms. Allen, please proceed.
Thank you, Your Honor. That open false imprisonment battery family violence case in Superior Court 25 SC 001360 is with the same victim in this case, Mrs. Taylor. He's out on a cash bond of $2,000 from June of 2024, requiring he have no violent contact. There was then the DeKalb battery family violence and violation of a TPO case. Subsequent to that, we also since then have a failure to appear and an open burglary case, Your Honor. This is an incident from the 30th. So today at about 1 in the morning, police were called to 1045 Regent Street Southwest. They responded to the location while talking to dispatch, the victim's call disconnected. Police responded to the location where they met with Mrs. Taylor. She reported that her boyfriend, who has lived with her previously, had come and assaulted her by repeatedly striking her with a closed fist in the back of her head. She reported that he was inside the house and was maybe going to flee out the back of the location. Police looked around for him in the area and then realized he was in the house. They saw him through an open window. He was directed to exit the location and refused to do so. Backup had to be called, and they actually obtained a search warrant before the defendant decided to voluntarily leave the location. The victim reported that they had argued that she'd gone out to her vehicle and he followed her where he repeatedly punched her multiple times. Your Honor, based on the history, including the open case of violence against the same victim, we're asking for a $6,000 surety, no contact with Ms. Taylor. Her name is Ted Launder, excuse me, TEDLONDER, Taylor. Stay away from wherever she's currently living. No drugs, alcohol, or weapons, Your Honor. And if you'd sound for Mrs. Taylor in case she's able to join us.
All right, is Ms. Taylor present? Wishes to make a statement? Okay, hearing none. Mr. McLean?
Your Honor, Mr. Pitts does have a McDonough card, so there would be no reason for him to be over at Regent Street if the court orders to stay away. So that would be fine. We would ask the court to consider the lowest possible bond in this situation. He is a local high school graduate. He has worked for years and years in the area of logistics for one of the large national companies, and warehouse work, also design work. We would ask for the lowest possible bond. If that is a signature bond, that would be great. But if it is not a signature bond, we'd ask the court to consider something in the $1,000 to $2,000 range.
All right, defendant will receive a $2,000 surety bond, broke down as follows: 1,000, count 1, 500 on each remaining count. He's to have no contact with the alleged victim, stay away from that location, have no alcohol, no drugs, no weapons as a condition. Is there anything additional from state or defense?
No, Your Honor, thank you.
All right, best of luck to you, Mr. Pitts. Mr. Fall, do you have the name of that person very quickly? All right, go ahead and put it into the chat for us, please. Best of luck to you, Mr. Pitts. Who do we have next?
We got, position 12, Mr. Swint.
All right, Mr. Swint, your case is 25 CR 002256H. You're charged with battery, family violence, cruelty to children in the third, and obstruction. Do you understand your rights?
Yes, ma'am.
All right, Mr. Howard.
Got an open simple battery, 2 counts. It's 25 CR 000519H. Open case out of Rockdale, cruelty to children, simple battery.
Okay. All right, thank you, Mr. Sirocco.
Thank you, Judge. This incident took place, it was yesterday, April 29th at 920 State Bridge Road in Johns Creek. It's the Quick Trip there. Law enforcement investigated domestic dispute, and it was discovered that the defendant had bitten his girlfriend, the victim in this case, Miss Felicia Stevenson. That's Felisha, and that's Stevenson with a V. On her right wrist, leaving a visible red mark, and scratched her on her inner right bicep, leaving a raised red mark and as well as broken skin while they were in their vehicle at the location. This incident was witnessed by their 4-year-old son, juvenile PS, who was sitting in the backseat of the vehicle while this incident occurred. The defendant and the victim share that child together. During the investigation, the officer informed the defendant that he was not free to leave the scene and that he was detained at that time. And the defendant proceeded to flee from the officer on foot, running behind multiple closed businesses before he was located, hiding in a retention pond down the road from the incident location, at which point he was taken into custody. Please bear with me for this next part. I promise it's not without purpose. The open case, the simple battery, 2 counts, 25 CR, that was referenced. In that case, it's the same victim. He's alleged to have pushed her into the floor cooler and having pinned her up against the cooler, preventing her from moving. Not only did that incident take place in front of the same juvenile as in this case, it took place in public, just like this case. The 911 call in that case came from a third-party passerby. In it, she stated he had also hit her in the car, and that there was a long history of him putting his hands on her, and that he'd been arrested before for putting his hands on her due to statements that their child made to the police. And that the defendant, according to her, believed that nothing would come of it because of his diplomatic immunity. He received a $15,000 surety for each count of simple battery, family violence, for a total of $3,000 surety. That was from Judge Mincy on February 1st. And as part of that bond, he was ordered to have no further contact with Felicia Stevenson, stay away from her residence, as well as complete 2 days anger management. Clearly, he's in violation of that. We were not able to reach the victim in reference to today's case. We would, of course, ask the court sound for her when appropriate, but I will add that we did speak to her in advance of C calendar for the previous case, at which time she did express that this is not the first time the defendant's been violent towards her. It's not the first time he's been arrested for it. And presumably what she's speaking to is it's a simple battery and cruelty to children in the 3rd degree arrest in Rockdale County from looks like July 20th of last year. Presumably she's speaking to that. But when she's expressed frustration over him having been released on insignificant bonds before on previous cases, and when we asked her whether she felt safe with having contact with the defendant, she replied, I guess. And when asked if she felt comfortable with him returning to the residence, she said, I think I'll be okay. And that she just wants him to be not violent with her. But the day prior to this, us speaking with her on the date of the incident, she expressed to the officer her fear for her own safety and advised that she would actually be staying with a family member whose address the defendant doesn't know. So that's concerning. And needless to say, the state is incredibly concerned here for Ms. Stevenson's safety. This is the second, at least, criminal case against her. More likely than not, his third. We're going to follow up on the Rockdale County case and confirm. But as if the actions alleged here and in the other case aren't themselves bad enough, this is at best the second incident with her that's taken place in public and in front of their child. That the open one in Fulton that took place in a Whole Foods. And it's just wildly brazen, not unlike his blatant violation of bond in that case. Given the substantial risk of reoffense here and that this is not, I mean, this appears to be a pattern of violence that does appear to be escalating. The state's recommendation is as follows. Hopefully you should have gotten a judge, but there was a second charge of battery family violence that came in. I've confirmed with Ms. Rogers that should have been added at this point. So if it appears to be 3, there are 4 counts. All right. For the 2 battery family violence counts, that's count 1 and 4, a $3,000 surety bond. For the cruelty to children in the third, a $3,000 surety bond. And for the willful obstruction, a $1,000 surety bond, for a total of $10,000 surety bond. The state also recommends the completion of FVIP, no further contact with Felicia Stevenson, stay away from the victim's residence, as well as the Quick Trip located at 10920 State Bridge Road in Johns Creek, and no drugs, weapons, or alcohol while out on bond.
Okay. Is Ms. Stevenson present? Wishes to make a brief statement? Okay, Mr. McLean.
Your Honor, 32-year-old Mr. Swint is in Georgia for over 25 years, so he's local. And high school graduate with certifications appropriate to what he does. Microsoft certifications. He does software. He works with communication hardware and software. He's done that for, I usually ask people 5 years worth. His experience in that area is more than 5 years. We asked the court under the circumstances to grant him the lowest possible bond, signature bond if it's possible, but if that is not, then we would ask the court to consider a $1,000 or $2,000 bond.
All right, defendant is going to receive a $6,000 surety bond, $2,000 on count 1, $1,000 count 2, $1,000 count 3, and $2,000 on count 4. That should equal the 6. He's to have no contact with the alleged victim, stay away from the victim's residence, as well as that Quick Trip. Additionally, he's to have no drugs, no alcohol, or weapons. I will not restrict him from the minor child. He can arrange that by coordinating with a third party. Is there anything additional from the state or the defense?
No, Your Honor.
Nothing.
All right, sir. Best of luck to you. That concludes your case at this time. Who do we have next?
Your Honor, if I can interrupt for just a minute. I still don't have that cosigner. Has anybody else received it? Nothing was placed in the chat for me for Mr. Falls. Position number.
Nothing for.
Nope, but he didn't give it. We need it. Who represented Mr. Falls? Was it you, Mr. McLean, or was it Ms. Bader?
Yes, Your Honor, it was me. I did chat when I saw the president. I chatted with Senior Mr. Falls and asked for him to call me, but I haven't called.
Okay, well, hopefully he'll come right back. All right, who do we have at courtroom 2?
Position 13, Mr. Thomas.
All right, Mr. Thomas, your case is 25 CR 002251B. You're charged with obstruction and terroristic threats and acts. Do you understand your rights?
Yes, ma'am.
All right, Mr. Howard.
35. 2024 out of Missouri. Resisting officer. Assault 4th degree, 4 counts. arson, 3rd degree. 2023 assault, 1st degree, 2016 resisting arrest conviction, and a 2012 theft arrest.
Okay. Ms. Allen?
Thank you, Your Honor. This is an incident from the 27th of April. The location is 6425 Oakley Road, apartment 804 in Union City. Police responded to the location where they met with Mrs. Hughes. Stephanie Hughes is the victim in this case. She reported that she'd broken up with the defendant and that since a breakup, he had been behaving erratically, threatening to assault her with objects, telling her he was going to bust her head open, that he had been drinking, that she was concerned for her safety. Police spoke to the defendant, who claimed he didn't know what had happened and said he'd been asleep. He became uncooperative and aggressive with police. He had to be asked multiple times to leave the personal space of officers. He was taken into custody for the terroristic threats against Mrs. Hughes. While in the patrol vehicle, he began slamming his head inside the patrol car and yelling at police. He refused to get into the car as ordered. He pinned himself against a vehicle and tried to throw himself to the ground after he was medically cleared. There's a concern. The state's asking for a social worker visit, Your Honor. Multiple cases out of Missouri arrest history do include the same victim, Mrs. Hughes, and he should have been served with a TPO that she obtained today that was sent over to the jail with the entry of service. We did speak to Mrs. Hughes. She reports that she did break up with the defendant. They share no children. She confirmed what happened and what's indicated in the police report. And she reports that the defendant's very violent and has been violent with her in the past, including prior cases in Missouri that I just mentioned. She reports that there's a substance abuse issue and she is fearful that the defendant will return to the location and harm her. So she did obtain that TPO today. He will need a one-time escort, Your Honor. We're asking for a $4,000 surety to stay away from that location, apartment 804 in Union City at the 6425 Oakley Road address. No contact with Mrs. Hughes, no drugs, alcohol, or weapons. And we'd request a social worker visit if you'd sound for Mrs. Hughes. Thank you.
All right. Ms. Hughes, if you wish to make a statement, please raise your right hand and unmute. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge and under the penalty of perjury?
You broke up.
I said, do you swear or affirm the testimony you give today will be the truth to the best of your knowledge and is given under the penalty of perjury?
Yes.
All right, you can put your hand down. I'm most concerned with concerns you have for your safety and desires for contact with the defendant. What would you like to tell me?
Sunday on the 28th, Mr. Thomas only had 4 or 5 items left in the house. He was already leaving the home. I called our insurance company to have
again,
them to.
before you go into that, remember the facts are not. Let me, you understand my instructions. I really want to know, most importantly, is if
Yes,
you're
ma'am.
concerned for your safety and if you want to, be in contact with him. But go ahead. Go ahead. What would you like to tell me?
I don't want to be in contact with him. They told me I can tell you this. That's why I'm explaining it to you. I put the rest of the items in his truck. I don't want Mr. Thomas around me. If he can have a police escort to come escort him to get his items and leave, but I don't want any contact with Mr. Thomas anymore.
Okay. Is there anything else you'd like me to be aware of?
No, ma'am. He can go his way and I can go mine because this is taking up too much of my time. I already took off of work for this. I don't plan to take off anymore. He can just get his items and go his way. I have the TPO in order, so that's protecting me, and I will go my way. I won't contact Mr. Thomas anymore.
Understood. I appreciate you coming to court and making that statement. I know that was difficult. Thank you, Ms. Hughes. All right, Mr. McLean.
Thank you, Your Honor. Mr. Jerome Thomas is 53. 11th grade, but past that, he has also obtained other training and continued to enhance his. He has a CDL. He does both local trucking and over the road. He's done that for over half a decade. Your Honor, this did go through a bind over and had one bond level set. But Your Honor, we would ask the court to consider, he's not going to be living there. We would ask the court to consider a signature bond if that is possible. And if it's not, we would ask the court to consider a $1,000 or $1,500 bond. Thank you.
All right, defendant is going to receive a $1,500 surety bond, 500 count one, 1,000 count two. He's to have absolutely no contact whatsoever with the alleged victim, Ms. Hughes. In this case, he should not call her, text her, send her a message via social media. If he sees her, he should turn around and walk in the other direction. He's to have no alcohol, no drugs, no weapons as a condition, and he's going to the May 13th state all-purpose calendar. I'm not going to do the social worker requirement at this juncture, Ms. Ellen. However, if the public defender's office wishes to send someone to see him, they can feel free to do so. Is there anything additional from state or defense at this time?
No, Your Honor. Thank you.
All right.
Thank you, Ms. Hughes.
Best of luck to Mr. Thomas and all parties concerned. All right, who do we have next? The last position, is it a party at ACDC? Did she hear her rights?
No, Your Honor, she did not. Ms.
All
Shelton?
right. Ms. Shelton, good afternoon. I'm Judge Melanie Williams. Your case is 25 CR 002250H. In this case, you're charged with theft by shoplifting and criminal trespass. Do you understand your rights?
Yes, ma'am.
Oh, I didn't tell you your rights. You have an absolute right to remain silent. You have a right to an attorney. And as you can see, I'm conducting this hearing by video. Do you understand all of that, Ms. Shelton?
Yes, ma'am.
All right. Thank you. I appreciate that. Mr. Howard?
52. On probation for reckless conduct. 24 SC 002702. On probation for trespass and shoplifting. 25 CR 0010939H 2024. We got the reckless conduct conviction, 2023 forgery in the 4th degree, NOLO. 2016 robbery and theft conviction, 2013 theft by receiving, theft by deception conviction. 2013 theft by receiving and 2012 theft convictions out of state.
Okay, thank you. Ms. Allen?
Thank you, Your Honor. This is an incident from the 20th of April. The Walmart is the location at 4735 State Route 138. That's in Union City. There are 2 counts here, theft by shoplifting and criminal trespass. Police were called to the location after a loss prevention officer observed the defendant walking around the store and picking up household items and concealing them on her person. They made contact with her and relocated her to the theft prevention office and then ran her information. They saw that she had a active warrant out of Union City, and she was taken into custody. You did just hear that she's got open, active probation cases here in Fulton County. Reckless conduct would have been reduced, and she was convicted of that instead of the aggravated assault that she was arrested for. This is a serious criminal history that includes violence, but also crimes of theft and basic annoyance. There is a concern here for the safety of the public and a concern for the defendant. That's why we're asking for a social worker visit. We'd ask for a $2,000 surety to stay away from that Walmart in Union City and no drugs, alcohol, or weapons. Thank you.
All right, thank you. Ms. Bader?
Yes, Your Honor. Ms. Shelton is 46 years old. She is from Ohio, but she's lived in Georgia for 4 years. She actually relocated to Georgia because she was in a terrible accident in Ohio where she needed to have surgery. She was life-flighted down here and she stayed. And her uncle and her mom came down here as well and live in the area. She didn't previously have a good address, which accounts for a lot of her prior cycles, but she now does with her uncle and their friend who is a reverend who is helping them get back on their feet. They live at 7420 Oakley Road in Union City. She did graduate high school in Ohio and has some college from Cleveland State University. She gets SSI. She's still having physical complications. Right now, she's not able to take the medication she's supposed to take. She's supposed to be going to doctor's appointments at Grady. She's supposed to go weekly for physical therapy. She had to learn how to walk again. So Judge, being in the jail is really affecting her physical health in a serious way. Like I said, the Reverend, she's gotten some community help to obtain her birth certificate again and retain housing. So she's back on the right path. At this point in time, we're asking for a signature bond. She does have somewhere to go. That's our request, Judge. It'll be difficult for her family to be able to afford anything.
Okay. I have to ask, what was the value of what she took, Miss Allen? Do you know?
Less than $500.
Okay. Understood. All right. Defendant is going to receive a $50 cash bond. It's going to be $25 on each count. She is to stay away from that Walmart, have no alcohol, drugs, or weapons while out on bond, and she's going to the state all purpose on the 13th. Is there anything additional?
Nothing, Judge, from me. Thank you.
All right. Best of luck to you, Miss Shelton. That concludes your case. All right. I believe we finished the entire calendar. Miss Bridgewater, will you please review it for me? I know we have that co-signer issue. Mr. McLean, did the gentleman reach back out to you by any chance?
No, Your Honor, not yet. I do have his phone number, but that's all I got. I don't have his email.
Okay. Mr. McLean, if you would perhaps attempt to give him a quick call while we review the calendar, I would appreciate it.
Okay, once again, the reset date for the SAP calendar is May the 13th. Position number 1 is reset further notice with a $3,000 SOB through pretrial with a co-signer of Rebecca Pace. Position number 2 is reset further notice with a $3,500 SOB through pretrial. Position 3 is reset further notice with a total $3,000 SOB through the jail. Position 4 is going to the SAP calendar with a total $1,000 good bond. Position 5 is going to the SAP calendar with a $25 cash bond. We're holding on position number 6 for the co-signer. However, it's being reset further notice with a $3,500 SOB through pretrial. 7 is going to the SAP calendar with a total $4,000 split bond. 8, SAP calendar with a total $2,000 good bond. 9 is reset further notice with a total $2,000 SOB through pretrial. 10 is going to the SAP calendar with a total $50 cash bond. 11 is reset further notice with a $3,000 SOB through pretrial. 12, SAP calendar with a total $6,000 good bond. 13, SAP calendar with a total $1,500 good bond. 14, SAP calendar with a total $1,000 good bond. Are there any questions, comments, or otherwise?
All right, hearing none, we will be in recess. I don't know what to do about that co-signer.
You just put adult cosign, I guess.
I guess, will they let him out with that? Because what I don't want is him to be sitting there.
It
I
looks
mean,
like
somebody have to cosign if it's adult. I mean, it's just,
it looks like
Oh.
Mr. McLean is on the phone, so I'm not sure if we could wait like 5 minutes.
We'll wait like two. We're gonna wait like two. Everybody else who needs to go can go.
Hang on. Your Honor, I do have him. There's a woman who's a friend of the family who is out of state. Now, I know when there's a bonding company involved, they require a Georgia address on an ID card or a
How's
driver's
she
license.
gonna come down and sign if she's not?
Oh,
Doesn't
we do that electronically, but if it's okay for her to be out of state, the language in what she's signing says be responsible for in the sense of
is that
making sure.
gonna work, Mr. Howard, when he gets down there?
Who get down where?
When his father comes down there and is trying to get somebody to sign
They just
electronically, is
they
that gonna
just
fly?
McLean can send them the link.
Right. And the woman who's going to get the link is out of state. The father can physically pick him up, but the person signing.
Okay, that's fine. That's fine. What's her name?
Okay, hold on. Sir, I've got you off resume, or I resumed your call. What is the name of the young lady?
Stacy Hill
And where does she live?
is in Florida.
Well,
Stacy Hill lives in
North
Hill?
of Palm Harbor.
Can I
Palm
get a
Harbor. Hang
spelling of
on.
her name?
Right. Stacy Hill of Palm Harbor. I assume that's STACY. I'll let you know if it's an EY, but let's go with STACYHILL unless we hear different. It's Palm Harbor, Florida.
Got it.
McLean, you have the link, right?
I'm about to get the link from him. I don't have it.
Okay. If it doesn't work out, please, someone let me know.
Sure.
All right. All
Thank you.
right. We will be in recess until tomorrow's SCA calendar, at which time you'll have Judge Morrow. Take care, everyone. Have a wonderful afternoon. It's always a pleasure. Bye-bye. I'm waiting on the orders, Miss Bridgewater.
It's coming at you right now.
Okay, coming at me. Bye-bye.
All right. Goodbye, everybody.
Hello?
Okay, let me zoom out.